She is just a tireless worker. She's an advocate. She writes for the Landowners magazine. She's a director of the Canadian Justice Review Board. She works for Jack McLaren doing some of his research, which has been tremendous. She's done a lot of work. She did some work for us, Jack, with the fairness, with the municipal and the interprovincial. She's a legal resident for the Green and Associate Law Office. She's a director of the Ontario Landowners Association International Property Rights Associate. And even on her card, she says, "I'm not a lawyer and do not give legal advice." But I'm going to tell you, she is extremely well sought after. She's on Nick Vandergrat quite often. Gets invited on there and just does a great job. So I'm looking forward to hearing Liz. Liz, the floor is yours. And thank you for coming. Where do you come? You come just Collingwood, correct? Or?
Yeah.
So you came up today?
It's a heck of a long way for a cup of coffee, I'll tell you.
Liz Marshall, thank you.
Coming tonight. Jack, you haven't got the memo, but this is all new information for you on the Green Energy Act. So, first and foremost, I'll tell you how we got into this. Dave Hemingway is the president of the Huron-Perth Landowners Association. And there was a farmer whose parents talked him into putting a turbine on his property. And he didn't want to do it, but he did it because mom and dad basically browbeat him into it. So then the turbine company showed up on this farmer's door wanting him to sign what's called an estoppel. So that means that he could not do anything about what they wanted to do with his property, and he didn't want to sign it. So he went to Dave Hemingway to talk to him about getting his patent and to see what he possibly could do to stop this situation. So Dave told him, you have to have a complete title search done and make sure you have your deeds and stuff. Well, the fellow went to do his title search, and a week before he had done this, the turbine company had placed a $420 million lien against his property. So he went to Dave with this information. So Dave went to the land registry office in his area. It's called something new, I have no idea. And they started digging up all of the demand debentures and the liens against all of the properties. And lo and behold, it's not just the leaseholders' properties, it's also the municipalities' property. Because the municipalities have entered into road user agreements that have been basically formatted by the Ontario Energy Board, where the municipalities, unbeknownst to them, are being used as security. So Dave is now up to, I think the last number was $4.2 billion worth of demand debentures and liens on leaseholder properties and municipal properties. Now, I actually, I've only been working on this for 3 weeks. I'm very tired. In those 3 weeks, I've learned lots. I brought my binder. I don't necessarily need it, but if there's any municipal representatives here, I have information in it. If you want to question me, if you're from Missouri, I can show you. So there's also been construction liens put against municipal properties as well. Up in Manitoulin, there were 24 farmers plus actually 5 municipal properties where construction liens were put against, and they were perfected. That means it went to court and they were perfected, and until it was paid, nothing could be done with those properties. So Dave has done some digging, and it was the same company in Manitoulin that got the demand debentures in his area. And shortly after they got those loans, then they paid their bill in Manitoulin. So they are actually financing everything with everyone else's money and property. None of their money is going into it. In 2009 in Hastings, there was a construction lien, and actually the planner did not know that this construction lien had been registered against the municipal properties, and the turbine company had gone bankrupt. So this is what we have been finding. Unfortunately for a lot of people, there is a huge amount of confusion in regards to the Green Energy Act. There is really absolutely nothing in the Green Energy Act in regards to the turbines. And when they created the Green Energy Act, they created schedules that went with the Green Energy Act, and you actually have to go, and it's not easy to find. You have to find Schedule G of Bill 115 to find out why there are so many problems with this. Well, Schedule G of this Bill 115 tells you that they have created a part in the Environmental Protection Act, and it is Part V.0.1, and they refer to this section of 47.3, which is supposed to be the regulation. But the thing is, though, when you're reading through section 47.3, subsection 1, you think, woohoo, here's the regulation, we got them. Except for subsection 2 exempts everything from subsection 1. So when you go to the environmental review tribunals to try and stop these things, you won't. You will lose. It's right in the legislation created to make you lose. Because the environmental review tribunal has to rubber stamp everything. Because actually, if you read Part 6 of the exemptions, it states right in there that they are exempt from having to seek any approval, any permits, any licenses, any regulation. It's right in the legislation. The things that they do have to do under this Part V.0.1 under the Environmental Protection Act is they must complete the applications properly, and if they decide that after they've created their plan they want to move one of the turbines or part of their solar panel array or whatever, they have to seek the approval of the director. That's the restrictions. So then we get into the municipalities. Now, the lawyers for the turbine companies have been using the Electricity Act, Section 41, subsection 9. And it states that the transmitter or the distributor may construct structures, put in facilities, and so on and so forth. So they run to the Ontario Energy Board against every municipality saying, we want 41.9 so that they have to give us a road user agreement. There is absolutely nothing in the Electricity Act that tells the municipalities they have to enter into the road user agreements. Because Section 41 is actually property interest. That's the section. It's under Part 3. This is only after there has been an easement created that Section 41, subsection 9 can be used. If there's a tussle match that the municipality doesn't want them to use that easement the way they want to use that easement. So the municipalities have been misled by the Ontario Energy Board and the lawyers. And I've been really digging into this because one municipality went as far as to challenge this in the Superior Court of Ontario. The problem is the lawyer didn't even ask the right question. The only question he asked was, can the Ontario Energy Board do this? He had no new evidence, he didn't present anything, the ruling is like half a page. And the judge is basically laughing at this lawyer going like, you have no question, you have no new evidence, and yes, he can do this because you never presented anything. And this is the ruling that set precedents for the municipalities. So they all think, and they are being told, that they have to enter these road user agreements and to get whatever they can out of these companies. They do not. There are a number of municipalities that have not entered into these road user agreements, and how do I know this? I met with them. You guys are probably going to fall off your chairs when you hear this. In the past 3 weeks, I have been working with a retired planner and a counselor putting a bylaw together. And this bylaw has nothing to do with the renewable energy projects. It has to do with upholding the Municipal Act, because municipalities cannot be used as a security for a third-party entity. It violates the Municipal Act. So what we are asking are people to get on their municipalities and say, do not take the money from the companies and do not pass the road user agreements. Now, when I worked with this planner and this counselor, we put it together, we constructed it in such a manner that we felt it was very clear. We had a legal opinion done on it. We sent it to one of the municipalities who had their lawyer go over it. That lawyer concurred with our lawyer in regards to the legal opinion, that it was a solid bylaw that could not be challenged. There is an option. So I went and I spoke to what's called the multi-municipal group in southwestern Ontario. And yes, I played nice with the mayors. And at this meeting, there was only 3 naysayers, but they have passed a resolution to take our bylaw back to their clerks to try and have it passed. That's huge. They have also extended the olive branch to every municipality in this province, because they've been fighting these for a lot longer than all of you have. They know the ropes, and they have been having some success. But it can be stopped. So that is up to your municipal councils. I've been emailing with Beth. I've been emailing with, what's that mayor's name?
Pierre Leroux.
Pierre Leroux. I've put him in touch with the multi-municipal. I'm leaving it up to the municipalities that I have had contact with to contact all of the other municipalities, because it's not my job to do that. And they have the networking system that they can do that. One councillor right now is presenting his motion to have this bylaw passed this past week. And I actually worked with him and the retired planner again, so that he would have the ability to shut staff up. Because it is actually staff, either knowingly or not, that are actually talking the councillors into this. And I can assure you right now, if a lawyer had actually read through the Electricity Act and realized that the Electricity Act was actually created for Ontario Hydro and then Hydro One, everyone would realize that those easements have already been created. And it's just like if a municipality has a gas pipeline coming through, they can say no. That's what it boils down to. But because of the Ontario Energy Board and this so-called format road user agreement, you taxpayers, and I'm talking even urban taxpayers, and you may want to get this point across to them, if there is a road user agreement, the municipalities can be used, and there will be demand debentures registered against municipal properties. And if those companies do decide to walk away, you, the taxpayers, will be on the hook for billions.
Already are.
I'm saying this is on top of what you already are. So that's the point you have to get across to your municipal councils. I'm not talking about health issues, because they've tried to do that time and time and time again. It fails because it's set up to fail. They know that. The Ontario Energy Board rulings it is set up for you to fail. And I'm very, very disappointed in legal counsel for these municipalities. Because if I can figure it out, and I am not a lawyer, surely to goodness they could take a few hours and read through the Electricity Act and the Municipal Act to know that A, there is nothing in the Electricity Act that says that municipalities have to enter into these agreements, and B, that municipalities set the terms if they do enter into these agreements, but they don't have to. And they cannot be used in any way, shape, or form as any form of security for anything. And yet it's right in the road user agreements. There are assignments in the road user agreements. There is secured party access in the road user agreements. And there's also the statement in the road user agreements that they will sign any future documents, doesn't matter what they are, at the behest of the renewable energy project. So how can a person or anyone actually enter into an agreement where you are agreeing to sign any document that they bring forward to you? Would you? The leaseholders are, actually. It's right in the leases. I've actually seen one. Someone actually came forward with their lease agreement. Their names and their address has been removed. There is a confidentiality or a gag section in it, and it's buried partly through. There is also